In a rear-end collision, is the car in the back always at fault? The answer is usually, but not always. Most of the time, if there are two cars, there's a rear-end collision, the officer who shows up on the scene of the collision is going to put fault on the vehicle in the back. In Georgia, the citation is going to be for following too closely, which is so common that you sometimes see it abbreviated as FTC. But that's not always the case. Most of the time, the officer reaches that conclusion. Most of the time, if you were to take a personal injury case to a jury, they're going to conclude that the person in the back is at fault, but not all the time. And today we'll talk about 3 exceptions to that rule. The first involves illegal parking. You can imagine what this is. Sometimes the vehicle is parked in the wrong spot. It might be parked in a way that the vehicle intrudes into a roadway, and passing drivers may not be able to see the vehicle or not be able to realize that the vehicle is stopped in time to avoid it. In such a circumstance, the parked car, not the vehicle that hits it in the rear, can be at fault for that collision. We had a similar but a little bit different case not too long ago. Our client was driving down a country road right at dawn. It was still fairly dark out. When he was on this 4-lane highway with a speed limit of 55, but he came upon a power truck that was moving down the highway. And although he didn't realize that that power truck was going 4, as in like 4 miles per hour. And he didn't realize how slow it was going until it was too late. So he runs into the rear and sustained some serious injuries. We were able to show that the problem in that case wasn't our client. I mean, you don't see taillights ahead of you and conclude that the vehicle is going 4 miles an hour in a 55 zone. The problem was that the power company hadn't maintained the truck well enough that it could drive at a regular speed. It was having a maintenance issue, so it was crawling along at 4 miles an hour at dawn. So in that case, we were able to recover well over $1 million actually on behalf of our client. The next example we'll talk about is conspicuity. Conspicuity is a word you don't hear a lot. It comes from the word conspicuous, and it just refers to how hard something is to see. You see conspicuity most of the time in the context of trucking cases, because tractor trailers or dump trucks or other commercial vehicles by law have to have certain things on the back of them to help other drivers see them, so you can't like miss the truck and drive into the back of it. And we'll look at some examples of that. Right here is the back of a tractor trailer that is complying with the federal motor carrier safety regulations, in other words, obeying the regulatory laws, and it has the correct equipment on the back. It has this red and white striped tape on the back, which we call conspicuity tape. It's just a roll of tape like that. So it's got that up here and down here, and then it's got adequate lighting across the back. So here, this truck is complying with the conspicuity regulations for the truck. And that's a good thing. It helps other people see trucks. It helps to avoid collisions because, as you can see from this picture, taken right at dawn or dusk, it looks like, the conspicuity tape works. I mean, it is really bright stuff. Some lights are shining on this, and you can see how reflective it is. But if a truck doesn't have that, then people can run into it, be hurt, and if the truck company wasn't complying with the regulations, they can be responsible for the collision. The type of conspicuity that's required depends on the type of truck. You know, this is a dump truck, and this shows sort of what's required on a dump truck. It would be different on a tanker truck, and you know, it's obviously different on a flatbed trailer. The last example we'll talk about today is sudden braking. And in case you call our office with a case about a rear-end collision where the other driver brakes suddenly, causing you to rear end them, let me tell you, these are tough cases, because you really, as a practical matter, to win them, need to be able to have some kind of proof that that's what happened. Because if you go to a jury and you say, oh, they braked suddenly, the jury is most of the time going to say, well, you still should have been able to stop, or you should not have been following too closely such that you didn't have time to stop when they hit the brakes. But occasionally, you can find evidence of this. We're handling a case now where a police officer, who probably should have had their blue lights on, swerved in front of a tractor trailer and slammed on the brakes, and then the tractor trailer rear-ended the police officer. The truck rolls over, and the tractor trailer driver is actually the one hurt, and that's who we're representing and trying to help. The state troopers, which, you know, sort of in the hierarchy of traffic police, they're kind of at the top. The state trooper arrives to investigate the collision and actually finds that the local police officer who swerved in front of the truck and slammed on his brakes was at fault. So very occasionally you'll find a time when sudden braking really did happen and really is the reason that the car in the rear of a rear-end collision is not the one at fault.